maybe some of you are unable to do so, so I'm going to mute for you, okay? All right, we are actually live on YouTube, and so as promised, I am going to share that link with you right now in the chat. Good evening, everyone. Hope all is well. We welcome you on tonight to our Is Your Business Straight webinar on tonight. We're excited to have you in the room. We're excited to have Attorney Saran. And definitely, we are also grateful to have Ashley in the room, who is blessing us tonight with American Sign Language to those that are in that community that need that assistance on tonight. And so there is absolutely no excuse because we have all avenues available on tonight. And so thank you again for joining. I promise you, I am not going to be before you long because I know that you need to get this meat tonight. And I know that it is going to come powerful because we have a blessed woman that is here tonight to take us into that labor room. And when I say that labor room, some of us need to give birth to our estate planning. Some of us need to get our business straight. And she is going to guide us on tonight in how to do so. And so, again, welcome back, Attorney Saran. We are excited to have you on tonight. I just put that YouTube link in the chat over here. And for those of you that are part of Free2Prayz prayer group, I am also going to send that to you. For those of you that are joining us on tonight, we ask that you would be so kind to share this at this time with your family members, your friends, and those that you know. Please go ahead tonight and share that with them. It is definitely going to be a wealth of information here tonight. What information that you don't have to pay for. That is the great thing about it. You don't have to pay for it. And so we're excited to have you all in this room on tonight. Again, please share. I see those that are still joining on tonight. We want to make sure that as many people get to partake in this as much as possible. And so thank you for your patience as we set the platform tonight. And we're going to make sure we're also going to share it to our Facebook page as well. So again, there is no excuse for those that need the information. So we're going to share it really quick, and then we're going to get started. All right. Let's see. We're going to put it in that prayer chat as well. So if you all need to share that with others that are not on the Zoom call, or be able to share it with them after this call is done, we would greatly appreciate it. All right, we're going to set up our platform on tonight. And so just give me a moment. We want to make sure that we've got it set up tonight. All right, so again, welcome. I am Charmaine, and I am the CEO of Free2Prayz Solutions Incorporated. It is a faith-based nonprofit organization that we started in 2020. We have been blessed to be around for 5.5 years. We're really excited for all that we have been able to accomplish in serving our community and providing to them uncommon solutions. It is a blessing when you have connections, when you have a network. It is a blessing when those who are willing, with a willing heart, that will come to this platform to share the gifts, the talents, and the resources that they have. And so we are very excited to have she's one of us now. That's how I see it, because they always say you visit once, and you're a guest. You visit twice and you're getting your feet warm. But she's back with us for a third time. And so this is awesome, awesome, awesome. And now she is Free2Prayz's family. And so tonight I introduce to some, I present to others, none other than attorney Seren G. Adams. She's going to take us further. And again, let us be respectful. So if you take yourself off mute, make sure that's only when you're asking a question. Otherwise, continue to stay. Come on, let's give it up for her on tonight. Let's give some hands up, hand clapping, some waves. Let her know that she is loved in this house. Attorney Seren, it's all on you tonight.
Thank you, thank you, thank you. I really appreciate being here, Charmaine. I appreciate you and you inviting me again
Yes.
back to the platform to be able to share this information. You know, I love sharing this information. It is a passion of mine to do this, so I appreciate being able to do it. And being invited back again is always a privilege, so I do not take that lightly. I'm going to go ahead and share my slides so Charmaine can make sure that it is up in the way that it's supposed to be on here.
Looks good.
Excellent. Okay. So, okay. Basically, everyone who's here really needs a congratulations on even making it here, because I know that there's lots of other places you can be. But it is something, estate planning is one of those things that usually keeps people up at night worrying about this kind of thing. And it's something you worry about, and then in the light of day, you kind of put to the back burner. But it's something that kind of keeps coming up usually for a lot of people, because it's something either like a fear of the unknown, or something that some people worry about if they talk about this, that it's going to cause something bad to happen, all of these things that we hear. But I can assure you that that is not the fact. And in fact, really, knowledge is power. So getting this information is something that I try to fill these workshops to the brim with as much information as I can. And really, the goal is that by the end of this, you'll be able to protect yourself and your family, because you'll have all the information you need to be able to act on this and give you the peace of mind that you need, so that instead of sleepless nights, you have that kind of peace to know what you need to do to protect yourself. So I'm going to be starting off with some basic things that you should know about estate planning. We'll go over the recommended estate plan that you should have in place, some of the available estate planning techniques using revocable and irrevocable trust. I'll even go over some of the fee ranges for doing general estate planning, so you can have an idea as well of what a general estate plan is gonna be costing, so you know what to be expecting. So let us jump in. Quick housekeeping for me would be to make sure you have the workbook. I uploaded it to the chat. This will allow you to follow along with the slides without feeling like you have to write down everything that's on the slides. These track with the slides. It's not like an exact picture of the slides, but it's the content of the slides. So you don't have to write all of those details down. And then you can just take notes about your questions. I will take questions at the end, because I know from experience, if we stop to take questions in the middle, we never get to the end. So if you can write down your questions as we go, so that we can cover those at the end of tonight. All right. So big picture question of something I always start off with in these workshops is that estate planning is not actually about you. It's actually about the people that you love. It's the people that you love the most that you actually do estate planning for. And when you say things to them like, I took care of everything, we want that to actually be true, which is why I make sure that the plans that we prepare actually will work. You want, when you say to somebody, I took care of it, that is actually the fact, and that you have actually done a good job of taking care of it, that you put things in order in the right way. So keeping the people that you love in mind and the people that you're planning for helps to nail home a lot of these concepts that we'll go over. So there's a place in your workbook where you can write that down. If you don't have your workbook, download it or anything. You can just write it down on the paper that you have in front of you, the people that you're planning for, because having that front of mind is helpful in terms of going through the material. So as we start off with just basic terminology, an estate, we start off there with just what the basics are. What is an estate? When we're talking about that, we're talking about all of your stuff. Personal property, real estate, financial accounts, and life insurance is included in your estate. We include life insurance. It's important to know that because the state and IRS are all including that when they're talking about your estate size for estate tax purposes. So estate taxes are also known as death taxes, and they're assessed on your assets after your death, but before those assets are distributed out to your beneficiaries. The federal estate tax is pretty high. It's 40%. But for most people, they don't have to worry about this because it's only assessed on really high estates, really high value estates. So estates over $15 million right now for the 2026. So most families don't have to worry about this unless the law changes, but the law does change. So it changes, this year it changed. The amount changes almost every year. Actually, in Maryland, Governor Wes Moore tried to change the amount in Maryland, which is currently $5 million. It's the same in about the same in DC. Wes Moore tried to reduce that amount down to 2 million as the estate tax threshold. So anything above 2 million was going to be taxed at the Maryland estate tax rate, which is 16%. So these things are in flux all the time based on what happens in the legislature. So it's something to pay attention to if your estate starts getting up to these thresholds. Key thing to keep in mind when you're doing estate planning is knowing where your estate is in this range so that if you start to get up into these higher thresholds, you can let your estate planning attorney know so they can help you to protect your assets because you do not have to pay estate taxes if you plan properly for some of these estate sizes. You can do planning to protect your assets. Sometimes once you get too high, you're going to pay taxes, but there are things you can do to protect your estate to reduce those taxes. Another thing to be knowing about in terms of your estate size and what's in it is being able to prepare a list of all of your property and making that list accessible to your loved ones so that nothing gets lost in your estate. There's over $1.6 billion right now in Maryland's unclaimed property accounts just from people passing away and their family members didn't know what they had. So it's certainly not what you want happening to your money, and you certainly can make a different plan and have that not be something that happens to your family. So making sure that you make a list and having those lists accessible to family members or letting them know where they can get that information. Another thing that is important for you to know about and avoid is state intestacy laws. So if you pass away without any kind of estate plan in place, the laws that are going to govern what happens to all of your stuff, those are called the intestacy laws. Most people have assumptions about what would happen when they pass away, but it's important that you know the reality because most of the time it's different from what you would have wanted. And it's most of the time different from the assumptions that you're making. For most couples, they assume, for example, that if one of them passes away, the other person's going to inherit everything, and that's not what it is in most states. For example, under Maryland law, if you're married and you have minor children and one spouse passes away, the other spouse does not inherit everything. It is split between the spouse and the minor children. And what that really means is that a guardian has to get appointed to the minor child's estate. And after that minor child turns 18, they inherit everything. And if you think back to when you were 18, it's not the greatest time to be inheriting a lump sum of money. It most likely means it's going to get wasted. So these are the kind of things you can plan against happening if you do the proper estate plan. Other things that can happen in the intestacy laws, if you are married and you have adult children, but those adult children are not the children of your spouse, that is getting split again, where you get a spousal allowance to the spouse that survives, and then half of the estate going to those children. So again, not things that most people assume will happen. And it's important to know these things so that if this is not the plan you want to have happen, you're putting what your wishes are in place instead of the state law. If you have no plan, the state has a plan for you, and you want to make sure your plan is getting put in place instead. If you have no living heirs or stepchildren, the Board of Education gets your assets in Maryland. So clearly, a better plan can be made if you just simply put things in writing in the legally binding way that is required in your state. So why do a plan? We call the things that you're trying to avoid by doing a plan modern day grave robbers in estate planning. So the first one of these things is probate. We'll go over in a minute why you want to avoid probate. But one of the other things that you want to be avoiding is mismanagement of your property. And this can happen if you're, for example, incapacitated and you don't have the proper documents in place to protect yourself and your property. So you pass, not even after you pass away, but if you're just incapacitated. So say you're in an accident on the Beltway and you don't pass away, but you're just in the hospital for a long period of time, but you don't have the proper documentation to say who should be managing your affairs if this is the situation that you're in. If you also don't have the proper instructions, if you do pass away and you're leaving property without the proper information. This can happen when somebody says to one child, I want this to happen, then says another child something completely different, and then you're leaving children fighting after you've gone. This can also lead to family drama, and I think that this is something all of us want to avoid. There's nothing worse than having a situation where families are fighting, or having families in a situation where it can be avoided if you aren't leaving a mess for them to clean up. Another situation you want to avoid is running out of money. And we see this often nowadays, not just from not saving enough for retirement, which is clearly a way you can have an issue with estate planning, but another issue we're seeing a lot of is running out of money due to long-term care cost. Because of the high cost of long-term care in the US. This is the issue with the Medicaid spend down, all of these scenarios that can come up for Medicaid forcing you to basically liquidate your assets and so forth in order to qualify for them to pay for long-term care. We bring these things up in estate planning because you can plan for an entire estate without doing this. And if you don't account for the Medicaid issue, the entire estate plan can fall apart because the costs are so high. So let's just look at this for a minute. The long-term care issue, at least half of the population is pretty much going to need some sort of long-term care. Alzheimer's is growing at a really alarming rate. About 55 million people worldwide are looking at Alzheimer's issues. I skipped a slide, let me go back. One of the other things that they're seeing is that people are living a lot longer with Alzheimer's. A recent study was showing that people are living up to 20 years after the diagnosis of Alzheimer's, which is a really long time to be living with this disease. Another thing they're showing is that caregivers are at a really high risk of developing their own health problems and sometimes passing away before the person who has Alzheimer's or dementia because of the stress of caring for that person. So all sorts of issues are coming up surrounding this. The cost of care, though, is one of the biggest issues. So average cost of care, and these numbers are coming from Medicaid directly. These are the numbers that Medicaid said are the average cost of care. And these are from where I'm licensed. In Maryland, it's $12,500 per month for long-term care. DC is even worse. It's about $15,000 per month to pay for long-term care. And when you're looking at that over the year for Maryland, that's about $150,000. So huge amounts of money that we're talking about just to pay for long-term care cost in a nursing home. A lot of times we'll think, well, I'm never going to go into a nursing home. I'm going to have family care for me at home. But if your family is physically unable to or medically unable to care for you because of what is going on physically, if you're looking at home health aides to help with that situation, they're also very expensive. Home health aides, and I had to look into this recently. My mom is living with me. Home health aides are about $30 per hour. They're very expensive. If you're looking at just 8 hours of care per day while you're at work, that's about $60,000 per year. If you need someone for 24-hour care because of memory issues or things like that, that's about $250,000 per year. So huge amounts of money. How to pay for these kinds of things. Payment options are going to include Medicare, but Medicare will only pay for the first 100 days of long-term care after a hospital stay. It's not the method that you're supposed to use to pay for long-term care. Medicaid is. Medicaid is what you're supposed to be using to pay for long-term care, but you have to qualify for Medicaid to pay for long-term care. In Maryland, you have to have less than, and this is pretty much standard for most of the states, but you have to have less than $2,500 in assets in order to qualify for Medicaid to pay for long-term care. So basically, you have to be dirt poor and really, really sick. You can also use your savings. That's another payment option. Not a great option because you have to use it all up in order to pay for long-term care. Another option is purchasing long-term care insurance. You can also implement a legal plan. We'll look at that in a minute in terms of being able to protect your home and your savings. But what usually happens is a combination of all of these things. By the time you're looking at having to go into a long-term care facility, most people are looking at all of the available options to be able to do that. Let's go over probate before we get into the long-term care plan types of things that you can do. Probate, if you pass away without an estate plan or without the proper estate plan, like if you just have a will, your estate has to go through probate in order to get distributed to your beneficiaries. And this last part is actually worth repeating because it's one of the major myths about estate planning. And one of the things that trips up most of my clients when they come in and is one of the biggest hurdles for us to overcome when talking with people, because this whole conception about wills and wills being enough and thinking that, oh, I have a will and so now I'm protected is a big myth. A will has to go through probate in order for it to be administered. It does not prevent probate. It is the thing that leads you into the probate court. Probate, I describe this as basically like suing yourself after you've passed away for the benefit of your creditors. It really makes no sense to do this if you can avoid doing this, and it can be avoided. The reason that it's something to avoid, number one, it's an administrative burden on your family at the worst possible time for them to be going through it. This is after they've lost someone important, they're mourning someone, and then they have all of these very specific documents that they have to file with the court with very specific information that has to be on it by certain deadlines. If they miss those deadlines, hearings are called. If they miss the hearings, they can be called back with a show cause order, all sorts of things connected with this court process because it is a court process. It's also costly. In Maryland, for example, we have it capped. It's a capped amount that you can charge. Of course, you can petition for a higher amount, but it is capped at 3.6% of the estate size. In DC, for example, it's not capped. You can charge whatever you want to as an attorney for probate. But for example, if you're capping it at the 3.6%, but you have a $500,000 estate size, which if you just have a house in most of the country nowadays, you're going to be over that $500,000 estate size. The probate cost for that size of estate is going to be about $20,000. That's already 4 times more than a good estate plan. So it really makes no sense to, again, spend the money, have your family losing that kind of asset out of your estate for something that you can avoid. It also causes a delay. The minimum time for a regular estate in this jurisdiction is 7 months. Most estates take at least a year to fully administer. The national average is 18 months to fully administer an estate. So quite a while that your beneficiaries have to wait in order to get distributions out of the estate. It's also public. The issue with it being public is that anyone can go to the Register of Wills office, find out who the beneficiaries are, what they're inheriting, when they're inheriting, and their contact information. So it really opens your beneficiaries up to predatory individuals, also to claims that could be completely false. If you're doing work on your home, any kind of creditor can just say they owed me for doing XYZ, and no one can know the wiser. So it's a system that invites predators, invites issues among family members who you may have not even left anything to, but they're invited into the process to scrutinize it because it is a public process and a court process. Probate, especially intestacy probate, and that's the kind where the state law, rather than your wishes, is governing what happens, can again be completely avoided with the proper estate plan. So let's look at a few different ways that you can actually avoid probate. We have joint tenancy ownership, beneficiary designations, or by transferring assets to a trust. All of these have pros, but the first two options actually have some significant cons, which is why trusts are the recommended way of avoiding probate. But let's look at all three of these so that we can understand why one is recommended over the other. So joint ownership, most people are familiar with this. If you've ever owned real estate with somebody or a vehicle with somebody, you understand how this works. If you own it jointly with somebody and one person passes away, the other person automatically inherits that property without it going through probate. That is the pro. You do not have a court process to do that. It automatically goes to that joint owner without the probate process. That's the pro. The con is when that second person passes away. Even if they have a will that says where they want it to go, it has to go through probate in order to get to anyone else after the last owner passes away. So it only delays the probate process. It does not eliminate it. Then you have beneficiary designations. A lot of people are trying to use this to avoid the probate process, but it has lots of flaws in it. The pro is that most people are familiar with this. It's like with life insurance or IRAs. When you even open up the account, they have you designate who the account should go to if you pass away, and it goes to that person after you pass away automatically. It does not go through probate to get to that person when you have a beneficiary designation on it. That is the pro. The con is, number one, making sure you've kept that designation up to date. This happens at least a few times a year. My firm will get someone in the office. They have never updated their beneficiary designations. They still have their mom or somebody else on the account after they've been married for many, many years, or somebody like somebody they've divorced still on a beneficiary designation. If you have someone on there and you pass away that you are not intending, it goes automatically to that person. It cannot be changed after somebody has passed away. It has to be kept up to date with who you want. Otherwise, that is who it's going to if something happens to you. Cannot be changed after the fact. If the beneficiary is no longer alive and then you pass away, that asset has to go through probate. So again, a situation where you potentially have not eliminated the probate process, just potentially delayed it. If the beneficiary is a minor or they're incapacitated or irresponsible, all of those are major scenarios that we see all the time and that have major cons associated with them. If the beneficiary is a minor, this is something we see commonly. Somebody will put their spouse and then their children as the backup beneficiary. If they're a minor and they end up inheriting that asset, same thing as we talked about before. It has to go to a custodian or a guardian has to be appointed. And it does not necessarily have to be the parent. So anyone can get appointed that the court decides. If it's not a parent, that person could end up charging a fee every month just to look at an account. So the child ends up getting less than you intended when they actually inherit. But the worst part is that they inherit it at 18. So again, not a great time for somebody to inherit a lump sum of money, when you can instead have them get money distributed over time if you're doing this in a different way. There's a different way you can set this up to make sure that it is not wasted. If the person is incapacitated, like they have special needs or anything like that, and they inherit a lump sum through life insurance, IRA, any of these beneficiary designations, a really dangerous situation for them because they will lose those benefits that they're getting. But what you've left them as a beneficiary designation is probably not enough to last their lifetime. So at some point, they're going to run out of what you've left them and then have to reapply for their benefits. But during that time period, they will essentially be destitute. They've run out of what you've left them. They no longer have benefits. They have to reapply and wait for the time period until they get benefits again. So very dangerous scenario to put someone in when you can leave it to them in a trust instead and make sure that they can keep their benefits and then keep getting what you've left them as a supplement to whatever they're already receiving. Much better way to do it. If you have somebody who has bad habits or they're irresponsible, again, another scenario where what you've left them can cause a bigger issue rather than leaving it to them in a trust where you can designate how they're going to receive it rather than this lump sum that causes a bigger issue for them. These are reasons why the trust is the recommended approach rather than beneficiary designation or through joint ownership. Through the trust, you can have all sorts of scenarios that are set up much better. In addition to the trust, though, these are additional things that you want to have in the recommended estate plan. A record of tangible and intangible assets, guardianship designations for minor kids, a durable power of attorney, an advanced healthcare directive, living will, and separate HIPAA authorization. If you want to be an organ donor, you also want to have an organ donation addendum. A last will and testament. You still want to have the will, just not as the primary thing in the estate plan. And then you also want to have a family trust or a revocable trust and potentially a irrevocable trust, which we call our legacy trust. So let's go over each of these. The record of tangible and intangible assets. We actually start our process at my office with an inventory of your assets. So you know, even before you walk into the legacy planning session, assets that you have, you're already starting to think about the list of these assets so that you can make sure that your family knows where your assets are and how to find them. This is something, it's like a great place to start in terms of estate planning, and you can do this on your own. Even before you start in your consultation, you can make a list of bank accounts, life insurance, retirement accounts, investment accounts, and what financial institution is holding these assets. Because if something happens to you and your family doesn't know anything about everything you own, these things can get lost. Again, there's over $1.6 billion right now in our state's unclaimed property account. I call it where money goes to die. The final step in our process is what we call our legacy interview, and it's where you can record things like your family stories, traditions, values, all of the things that make you you and the things that are important to you. And it's also things that should not be lost. It's things that you really should have as part of your estate plan and pass down to the next generation. So this part of intangible assets is also something that should be part of your estate plan. You also want to make sure you have guardianship designations for minor kids if you have minor kids in your family. And this is something, even if you're a grandparent, to make sure that your children have this in place for your grandkids. It's something that is completely overlooked in traditional estate planning because most traditional estate plans just have this addressed in a will. But a will only governs what happens after you've passed away. If you have a scenario where somebody has gotten in an accident or they're just incapacitated, nothing in the will governs what happens with your kids. And this is a big gap in estate planning. You have to have documents that specify what should be happening with your children if you're incapacitated so that they're never at risk of being taken into protective custody or anything like that if you don't make it home from date night or from work or anything like that. You always need to make sure instructions are there and that the person who you want in charge of your children has the proper documentation to be able to take your kids into custody and make sure that they are taken care of. And that if there is somebody that you don't want to take your kids, that that is also specified. Durable power of attorney. This is important to have in every estate plan if you are, again, incapacitated, so that you have someone who can handle your financial decisions, things like collecting your mail, paying your taxes, paying your bills. Any of these things that you can only do with your signature, you need the power of attorney agent to be able to do with this document. Otherwise, you're asking family and friends to commit mail fraud, bank fraud, forgery, just to be helping you out with your affairs. Something you don't want to ask your family and friends to be doing for you. unless you give them the proper documentation to do so. And you also want to make sure you have documentation so you're naming the right person to do this and not just letting anyone who raises their hand in your family and says, I'll take care of it, handle this for you. The Advanced Healthcare Directive is basically the medical version of the power of attorney. And this is what specifies who's able to handle medical decisions if you're incapacitated and also get access to medical records. The HIPAA authorization, same thing, allows that right away after you've become, after you've passed away as well, so that if there's a medical malpractice issue, it allows access to those records to prove that medical malpractice issue, because the advanced directive as well as the power of attorney expire with you. So that HIPAA authorization extends for those 2 years after your death for those medical records. The living will is part of your advanced directive and lets you specify what your end of life wishes are so that you can say whether you want to be kept on life support or not. And then your family is not guessing at what to do and then feeling guilty later about whether they made the right decision. You want to be able to make those decisions and then have your family just have the honor of carrying out your wishes and not guessing later. And then if you want to be an organ donor, that can also be part of your advanced directive. The will should be part of your estate plan, but again, not the primary tool if you own property or you have children. If either of those scenarios apply to you, you should have a trust in addition to a will, because the will, again, goes through probate. Primarily what you want the will for is just designating who the guardian of minor children are after you've passed away, and specifying things like whether you want to be buried or cremated. The legal function of the will is to specify who's in charge of your probate estate, and if something is going through probate, who gets what. But again, who wants to go through probate? So you ideally are using a trust to govern who is getting what in your estate. The trust is a separate legal entity that you set up. Think of it similar to creating an LLC or a corporation. And the separate legal entity that you set up is there to manage your assets while you're alive, and then also be able to distribute those assets after you've passed away in a much more efficient way and also a much more creative way. You can be really detailed and specific about how assets are distributed when you're using a trust, and it has much more protections. And the trust can be revocable or irrevocable. And whether it's revocable or irrevocable, it's going to have certain people or parties in it that make it work. First person or party people in it would be the grantor or settlor, same thing. And that would be you. That's the person who creates the trust. The next party or person in the trust is going to be the trustee. And the trustee is the person that manages the trust assets. Think of that like the CEO of the corporation. In a revocable trust, that's also you. You're the person who manages the assets that you put into the trust. Anything you can do with the assets before you put it in, you can do as trustee of the trust when you put it in there. You can sell your house, you can access your bank accounts, all of the things you could have done before, you do as trustee of the trust. You also would name a successor trustee of your trust, and that's the person who's going to step into your shoes if you become incapacitated or after you've passed away. And that person obviously should be somebody you trust, hence the name trustee. And this is the person you're trusting to carry out your wishes that you've specified in your trust. Then you're also going to have beneficiaries of the trust. And the beneficiaries are the people who receive the benefit of the trust assets. In a revocable trust, that's also you. You receive the benefit of the assets you've put into the trust. You live in your house. You receive the benefit of your bank accounts, all of the things that you did before. You receive as beneficiary of your trust when you put it in there. But then you also have additional beneficiaries after you pass away, like your children, charities, whomever you choose, and when you choose, and how you choose, which is the big difference between a trust and a will, is you can be really specific and detailed with the how. So one of the big things to know about a trust is that it literally is just a fancy stack of paper, a very expensive fancy stack of paper, unless you actually fund the trust with your assets. And funding the trust means that you retitle or assign your assets into the name of the trust. This is a key thing and one of the main things you should be looking for when you get a trust plan. Don't just get a plan and have someone say to you, okay, go fund it, because this part is key. If you do not fund a trust, and this happens all the time, we get clients who come into us with old estate plans and they're coming to us because it's not working, because the trust actually has to be funded in order to work. If it isn't funded, you're still going through probate. It's literally doing nothing. This is also the key reason you should never try to do a trust on your own, because you actually have to transfer your assets into the name of this legal document. If you have not drafted this properly, it's really dangerous, and you actually could be making a bigger mess than what you are fixing, because you have to do things like transfer your home into the name and title of the trust, transfer bank accounts, investment accounts, your actual assets and funds into the name of this trust. And if it's not properly drafted and done correctly, again, could be creating a bigger mess than what you are solving. So the best way to think about revocable versus irrevocable trust is to think of a treasure chest. We call our family trust which is a revocable trust. Think of that as a open chest. So you can put assets in that kind of trust. So you can put a house in there, bank account in there, investment accounts in there. It's an open chest. So you can also take things out of it at any time. Once you put it in there, you can take it out the very next day. You can take it out 10 years from now. You have complete access in and out of that kind of trust. You're the grantor, you're the trustee, you're the beneficiary of this kind of trust, revocable, and you have complete control over it. Because you have complete control over it, it's not an asset protection tool. It's used for estate planning and to avoid probate. The asset protection piece of it would be if a creditor couldn't get into it. Creditors can get into this type of trust through you because you can get in it. So if you had a judgment against you, a creditor can make you go in and get to your assets to pay them, because it's not an asset protection tool. The big benefit of it, though, is the probate court. Once you put something in here, the probate court will completely ignore what you have put inside of this type of trust. Very effective tool for probate avoidance and for planning for your beneficiaries after you're gone, and for managing your assets while you're alive and incapacitated. So great planning tool for estate planning purposes. Now think of the legacy trust, which is also treasure chest. So you can put assets inside of it as the grantor. Your house can go inside of it. You can still live in the house. Bank accounts can go inside. Investment accounts can go inside. But when you put assets inside of this type of treasure chest, you're going to close the lid on this chest and you're going to lock it. And then you're going to give the key to somebody else. And that other person is going to be somebody you trust, like an adult child, the one that you raised really well and that you trust, the good one. Because this person is going to be the one who can access this treasure chest for you if you need something, and is going to take care of you with the things inside of this trust that you've put inside of here. It's a great tool for not just probate avoidance, because again, the probate court is going to completely ignore everything you've put inside of this chest, but it is also a great tool for asset protection and for Medicaid planning purposes. The asset protection piece, because if you have a creditor that has a judgment against you, they don't have any control over the person you gave a key to. So they can't force that person to access the things inside of the trust to pay them. So it's a great asset protection tool. It's also a great Medicaid planning tool, because Medicaid will also ignore anything you've put inside of this chest after the 5-year look back has passed. So great tool for doing that, and why we use these tools, these irrevocable trusts mostly nowadays, is for Medicaid planning. Some of the other reasons we use this would be land trust. If you have like investment properties and things like that, or rental properties, you can use it for this kind of purpose. We also use it for privacy reasons, if you want to shield assets from creditors and things like that. We also use it for high net worth individuals when we're doing offshore trust planning. So lots of great asset protection tools with irrevocable trust. Lots of things you can do with them. With the regular trust, and this is actually the case with all trusts, but you can, all of these other things are really the benefits of being able to do trust planning. Avoiding probate is one of the big benefits, which we already talked about. You can also um, control how distributions happen with your beneficiaries, which is a great tool to be using trust planning for. So when we talked about minors before and then potentially inheriting at 18, that can be completely avoided when you're doing a trust plan because you can determine when somebody is going to inherit. You can have assets held in trust and used for their benefit when they're minors. And so your trustee can distribute to them when they're still a minor for their health, their education, their maintenance and support. And then when they turn certain ages, they can then get lump sums distributed to them. Like what most people do is when somebody turns 25, a third distribution, and at 30, another third, and 35, another third. But you can pick whatever ages that you want, whatever percentages that you want. You can be very creative with distributions in a trust. If you have beneficiaries that are not great with money, you can also do things like require that they meet with a financial advisor before they get a lump sum distribution or take a financial management course. If you have somebody that has any bad habits, like we mentioned before, or irresponsible beneficiaries, you can require that they take drug testing before they get distributions. We had a scenario just like that, where the sister of one of our beneficiaries was in drug rehab at the time we did her plan, and we set up the plan where she had to do drug testing before she got a distribution. If she failed the drug test, her distribution stopped and she had to redo testing before she got any more distributions. The distributions would drop down if she failed another test. It was all of these steps that she had to go through in order for her to continue getting distributions and for the distributions to increase. So you can incentivize behavior with how you set up the plan. You can also set up the plan to kind of match what your legacy goals are. So if you have a goal of doing real estate investment, or that's something that you're passionate about, you can say you can have distributions if you want to set up or purchase real estate, or if you want to start a business, if you're an entrepreneur and that's something you want to leave as a legacy. You can set things up around the things that are really your area of passion that you want to continue on for your legacy. All of these things are things you can really create in a trust plan. You can also do asset protection for your beneficiaries in a trust. If you have adults who are going to inherit and you're worried that they would be facing a divorce or they would have a tax issue or be sued by someone in the future, you can set up your trust so that they are protected from those creditors by how you set up the language inside of your trust. You can even protect for things like a future spouse remarrying and preventing that spouse from having assets distributed to a future spouse or future kids that are not your kids. You can require things like a prenuptial agreement be signed if your spouse remarries. So all sorts of things you can set up in a trust. Also, if you have assets or real estate in multiple jurisdictions, like if you inherit property in North Carolina, you can add that into your trust to make sure you don't have probate in multiple states. All of those things can be included in, and it also avoids guardianship so that you don't have to go through guardianship if you are incapacitated in the future because you've already named a trustee who's going to be managing your assets for you. It also reduces costs because your trustee is already given instructions on what to do in your trust for how to administer things. So you do not have to hire an attorney to administer a trust plan. So the legacy part of this is really the part that you want to really be thinking about in terms of why estate planning is important, because regardless of whether you have documents in place, the part that your family really cares about is that you did the documents. And I always say to people, no one's going to put your trust or your will on their nightstand to remember you by. What they really care about is that they have something to remember you by, but for sure they want to know that you actually did a plan and that you put this in place. The legacy aspect of it, the legacy interview and making sure that your wishes and your legacy is really incorporated into your plan is how you can make sure that your legacy is part of your estate plan, and making sure that you've done this in a way where you're really leaving an orderly set of instructions for your family to be able to follow and not a mess for them to clean up after you're gone. So where to start in terms of estate planning? Definitely preparing that list of assets, gathering recent account statements to help with that is always helpful. Deciding who you want in important roles, like who you want as your successor trustee, who you want as your power of attorney, all of those things, and getting their contact information. If you start off your questionnaire with all of that information in hand, the questionnaire usually only takes you about 15 minutes because you have all of that information already. Thinking about how you want your beneficiaries to receive what you leave them and any special instructions that you want to leave. Having that kind of information already in mind before you do a consultation with the attorney is always helpful, because then you can focus on really tailoring your plan to what your estate planning goals are. And then scheduling complimentary consultation. We do complimentary consultations at my office for anyone who's done one of these workshops, because it saves us a lot of time if you've already done this. But making sure that you actually meet with somebody to get this done and not just learn the information and not take action with it. Our process, if you are interested in meeting with us, we do our legacy planning session for the consultation, where we actually meet with our clients and go over their planning goals. We talk about what you're trying to accomplish, go over your family situation to make sure that we're mapping what you need with what our plans are. We then, once you decide what your plan would be, set up a draft of your plan that you actually review. That part we feel is very important, that everyone actually takes a look at your plan before you're signing it. So we actually send 2 sets of drafts. The first set is just confirmation of the information that you've given us, and then the next set is the actual estate plan that you would be signing. And then your signing ceremony is usually in about 4 weeks from when you meet with us. And that's also when we do the legacy interview, where you record the family stories, the family legacy part that you want to incorporate into the plan. And then we actually help you with funding. This part I feel is really key, because we get so many people who've come to us with estate plans that they thought were going to work, and they literally are doing nothing with the plan because the plan is leading them into probate, because it isn't funded. The funding aspect is so key and important. And so we help you do that entire part of it. And the funding part usually takes anywhere from 2 to 3 weeks, sometimes longer if any of the banks have changed their forms or anything like that, but we make sure we get that part accomplished, and that's included in our entire plan. This gives you an idea of the fee ranges for the different types of plan, the main types of plans that we offer. Our will plan, which again, you would only be doing if you don't really have assets that would go through probate. So this is for like families who are just starting out, who are mainly looking for like a power of attorney and the kids protection plan type of documents. Those are $2,500 for singles, $3,500 for couples, and it goes up to that legacy plan, which is the irrevocable trust plan for Medicaid planning to protect against the nursing home cost of, tens of thousands per year, or per month, I mean. The single plan at 6,000, couples at 7,500. Most of our planning is in that middle area where we're doing revocable trust plans. And that's about 4,500 for singles and 6,000 for couples. And you can add into any of these plans the beneficiary asset protection that I mentioned, and so forth. So there are all sorts of different things you can add in and do differently, but that's the general ranges of what most of our plans are. And hopefully you know by now what the best plan is, which is the plan that actually gets created. One of the biggest dangers, I think, in terms of legacy and even just your family's well-being is really procrastination, is putting off estate planning. Because putting this kind of thing off just means that you're putting your family at risk. And I think that's the thing that keeps people keeps them up at night. It wakes you up and makes you think about these kind of things in the middle of the night. And then again, by light of day, you put it off and forget it again, but wakes you up again. That's why one of our key things that we make sure we do at my firm, if somebody raises their hand to us and says they want to do this, we do everything we can to just keep you on track towards this goal of getting this done. So we try to make sure that we can have that as part of our process to make sure you have peace of mind at the end of this by getting it actually accomplished. We always also offer, and you'll see this in the back of the handout that I gave you, we give a discount of $250 off of our estate plans if you sign up with us after doing one of these workshops. We also do our legacy planning session, which is normally $750. We do those for free if you've done one of these workshops. So this discount is available to Charmaine's guests. And that's in the back of your workbook. And this is info on how you can set up consultations with us. And that's also in the workbook. And then we wanted to leave time for questions. I think I ran over, Charmaine, but I think can still do some questions. I'll leave that up to Charmaine.
Yes, that will be fine.
Okay. All right. Well, let's do some questions.
So if you all have questions, you can unmute yourself. You can ask the questions, or you can also post them in the chat. That goes for those of you that are on YouTube as well. You can unmute your phone at this time if you have any questions or need clarification, need any additional clarity on any of the things that were talked about tonight. You may ask at this time, but you may need to unmute yourself.
So I do have a question, the interpreter here. Do you only do Maryland, or do you also cover Virginia as well?
I am licensed in Maryland and in DC, but if you are out of those two states, you can email my office at support@adamslawoffice.net, and we can send you a link to a firm that would be, not a firm, but an attorney referral service that will be able to serve you in the area where you're located that we think would be good. There are a couple of referral groups that we're with that we would trust that the attorneys in there would do a decent job. So you can email us and we would send you some information.
Okay, so I have another question. If you already have a will, because I've called you a few times and I haven't gotten a reply back. But if you already have a will that you need read over, does your company do that as well?
So we can do that. That's a paid consultation. And what we usually recommend, though, that's an interesting question. I'll say that, because what ends up happening, we usually try to talk people out of that, because what ends up happening is you end up paying for that service. And most of the time, what we have found when we've done that is we recommend that you get a new estate plan. Because the reason that you're having us review it is you think something is wrong with it, and you're usually right, and we usually agree when we review it. So you've ended up paying for us to review it to tell you something's wrong with it when you already knew that, and then you still end up paying for the new estate plan. So I, many years ago, started telling my intake person, if you can talk people out of doing this, because I feel really bad after doing the kind of consult that ends up being, is then having to still tell somebody you're still going to need another estate, because it's almost like you're paying twice. And you already started off knowing there was something wrong with that plan. You called us in the first place because you wanted to confirm to you that there was something wrong with that plan.
Well, my situation was a little different. That's why I was calling.
Okay.
But I never got, like I said, I never got an answer. But my situation is a little bit different. So
what was the, do you want to, you don't want to, well, okay. If you want to email me, I can talk to you.
Offline.
Okay.
Because it's a lot. Offline.
Okay.
All right. Any other questions or feedback you want to share tonight? Please just unmute yourself and go ahead and share.
Sharon, I have a question.
Uh-huh.
Why do you think people are afraid, or do you think they're afraid? They don't want to be bothered. They just want to be a punk. They don't want to. Why is it that people don't want to get their business straight? Some just don't want to do it. I've seen so much in the last couple of years, friends and family,
Yeah.
where they just outright refused to do it. I'm going to do it. I'm going to do it. This is it. I'm going to do it. And they never do.
Yeah,
And then,
procrastination is tough. And I think it's honestly, it's a personality thing, I think, because some people procrastinate and some people procrastinate a little bit, and some people are just, they don't procrastinate at all. And you fall in one of these categories. And I think with estate planning, most of the population, most of the population procrastinates. I forget the statistics, but it's a high percentage of the population puts off estate planning in general. So that's already a given because no one wants to think about their end of life. So then on top of that, you have the normal personality, your normal personality of wanting to procrastinate things that you don't want to deal with. So the combination of the two is what happens with estate planning in general. And usually what ends up with when we see someone who's ready to do this, they've usually had a situation happen. Either they've gone through probate recently, or they've seen a family member or friend go through probate, or they've had a health scare. Something has caused them to realize the urgency of this, or they're just tired of thinking about this in the middle of the night and they decide to get it done. But my favorite part about estate planning is the moment at the end of the signing ceremony because literally you can see the weight of people, the weight of the world come on. I don't think people realize how much stress they carry around when you know you have to do something and you keep putting it off. You
mhm.
don't realize the stress you're carrying around. We see how the stress leaves when people have gotten this done at the end and they're like, oh my God, it's finally done. Like they walk in on the day of and there's still this ball of tension. We're like, hey, happy signing. We're happy to see them because we know what's coming, but there's still a ball of tension. And then at the end of it, it's just like this melted away piece of, knowing they got this taken care of and finally it's done. That's
Mhm.
our favorite thing. So we get to see that all the time, but everyone isn't seeing how they feel at the end. They just see the, oh God, I have to do this. So I think that's what happens.
Okay. It's just since your first podcast that you did, the presentation, I just thought it was wonderful and it was so much good information that you gave.
Ew.
And I shared it with a couple of family members and friends. And since that time, at least four of them have passed away,
Oh,
they had a,
wow.
or they had a spouse or family member to pass away,
Oh,
and it and it the whole thing was just a mess that could have been avoided. And and I'm constantly telling people, family and friends, to go and do this. Go do this. It's how important it is.
mm,
And okay, I'm gonna do it. I'm gonna do it. And the next thing you know, there's a death, and of course it's not done. And
mm,
then I find that some people are just as I said, they're punks. They don't want to name. They don't want to name. They don't want to put one person in the family in charge.
mm.
So they just feel that if I don't do anything, it's I don't have to deal with it. Um, I just wonder. Hmm.
Yeah. I mean, to me, you really, even if you have a situation where you don't have great choices of family members to put in charge, it's better to have some decisions made than
Hmm.
leaving it to chance and the mess of, undecided things for family to clean up, especially if you already know you have family that isn't going to be great at doing it. At least have your wishes laid out. So, even if it's people who aren't great with administration and doing things, the plan is that you've laid it out.
Mm-hmm.
Anyone who's named in an estate plan to do something, they have a fiduciary responsibility to do what you've said to do. It's not like they have a choice of what they're doing. You're telling
Mm-hmm.
them what to do.
Mm-hmm.
So it's always better to have a plan.
Okay. Thank you, ma'am.
Thank you.
Hey, I have received two comments. One said it has been very interesting on tonight. One says, thank you so very much.
My
And
pleasure.
they are excited to talk with their family and to start their process.
Excellent.
So good news on that part. So thank you very much to those of you. Any other feedback on tonight, you can feel free to unmute your phone and let Attorney Seren know that you were listening tonight and that you enjoyed this presentation on tonight. Is it because y'all are muted? You don't know how to unmute yourselves? Because I have a talkative bunch here tonight. All right, I'm going to try to unmute a few of them and let's see.
That's one of her businesses.
Okay, hold on. Anyone else that would like to share? I'm going to unmute everybody and you can, if you've been talking, is anybody, did everyone enjoy the presentation tonight?
Absolutely.
Very much, very much
there
so.
you go.
Very much. Very much so.
All right, awesome. We want to give up to Ashley for being our American Sign Language interpreter tonight. Thank you so much.
Yeah,
I
thank you.
know she has to go. Thank you so much, Ashley. Appreciate you. All right. Well, I know what's gonna happen. We're gonna get off, and then you're gonna send me all the questions, and that's fine. That's fine. We'll make sure that Attorney Seren gets them. Thank you
Yes.
again, Attorney Seren. You're always a blessing to us. We thank
My
you
pleasure.
for always availing yourself to share with us so that we can be more empowered and more strategic in our estate planning. And so thank you from the bottom of our hearts. Again, if you have questions, this will be on YouTube, so you can go back and you can get some of that contact information, or you can contact us directly and we will make sure that you get in touch with her. If I was you, I would take advantage of that golden ticket as well as the complimentary session. It's no reason why, no excuse why you can't do it, because it's complimentary, which means you can have it. So let us be intentional about that. Also, if you need me to email you for whatever reason you could not get in the chat to print out or to use the workbook tonight, you can certainly contact me and I can go ahead and email it to you to make sure that you have it. And for those of you that need a paper copy, I don't mind making a copy for you and mailing it to you. Thank you tonight for your attendance on tonight and your presence. We had about another 15, 20 that were also on YouTube watching as well. And I received a few text messages of those who are going to watch the replay because of other obligations. So now you have a job, and that is to now share this with your family members, your friends, your neighbors, your coworkers, your church members, so that we can all be on one accord. There's so much going on in the world, everyone. And so we want to make sure that we're not getting ready. I preached that on today, that we're not getting ready, but that we are ready when that time should come. As it has been stated, you don't want your family to have that extra headache when they're already trying to grieve you. You want to make sure that their heart is just focused on grieving and not dealing with the nonsense that comes with death. So we are counting on you to be an agent of change. We're counting on you to step up to the plate and to make sure that your legacy is left the right way. I love you all so very much. Thank you again for joining us on tonight. Certainly, we will have some other stuff coming up and we will be in touch. But until then, have a blessed night and thank you, thank you, thank you.
Thank you.
Thank you, Sharon. Thank you so much.
My
Thank you.
pleasure.
Thank you.
Good
Thank
night.
you so much.
Thank you so much. Have a good evening.
Pleasure. Good night.
Good evening.
Thank you.